Welcome. With the government's new insolvency law reforms coming out in the new year, we at SV Partners thought we would bring you some short clips around what might be happening in the new year, what these new insolvency reforms might look like, and how they might impact upon you, your clients, and your business. Now, these reforms are being touted as the biggest in 30 years, so now's the time to try to understand how they might impact on you and what we might be able to assist you with. My name is Matthew Hudson from SV Partners. I have done a number of videos over the last few weeks trying to bring to you what all this might mean with the new regulations and rules only just coming out. It's an evolving circumstance. So today I want to go through some of these new changes, explain to you, how this might actually work. So basically, the two reforms that are coming out, one is called a simple liquidation, and we'll go through that in a second. And then the second one is what's called a small business restructuring process. So the first one I want to deal with is the simple liquidation process. Now, the reason why I want to start there is I think it's probably the most easiest one to explain and I guess get to the side, because the restructuring process is quite difficult and quite technical. Now, with the simple liquidation, what I want you to think about is it's a director-initiated liquidation. That's what's called a creditor's voluntary liquidation, and don't get that confused with a creditor putting you into liquidation or your company into liquidation. It's where you as the director shareholders vote to put the company into liquidation. Now, that CVL, Creditors Voluntary Liquidation process, has been around for a long time. But what the government is looking to do is reduce and reform that so that it's a cheaper and more faster process. Now, whether or not that's actually going to be achieved here, that's still devil in the detail. We're waiting on all the regulations and rules to come out, and that's an evolving process. But basically, what they're looking to do is say to directors, businesses, creditors, if you elect to go down this simple liquidation process, the liquidator won't have to do as much work, they won't have to do as much reporting, the creditors won't have as many rights necessarily, but where you have a very small company, a company with less than $1 million in debts, then hopefully, and this is definitely a hope, then the process will be a lot cheaper for everybody involved. Now, there's some eligibility requirements here to be able to do this process. As I said, it must be what's called a CVL. There are many other different types of liquidations out there, but those don't apply. This must only be a CVL. As I said before, you must have liabilities less than $1 million. Now, unfortunately, that does include secured creditors, which is quite interesting, but it does not include contingent creditors. Now, contingent creditors has not been defined. We don't actually know what that necessarily is going to mean. But I think probably the simplest way to describe it might be something where it's a court action. You're defending, a plaintiff is pursuing you as for a debt, for instance. You might be contesting it, and because they haven't won yet in court, that might be deemed a contingent debt. Not to say it will be, but it possibly could be. So as long as you're below that $1 million threshold, you can potentially adopt this simple liquidation process. The other eligibility requirements are sort of technical. It requires that you have not done this process in the last 7 years. You or a past director have done this in the last 7 years, and you also must have lodged all of your tax returns, which is quite a difficult thing, especially from our point of view, to be able to meet. It might just be as simple as you miss one tax return from 10 years ago, and that could potentially make you ineligible. So, there's some things there that we would really need to sit down with you and just make sure that all of these boxes are ticked before you go down the process. But probably the biggest issue that's been identified to meet this eligibility really comes down to the time frame. So what happens is you appoint a liquidator to do this CVL. You do the CVL for the first, say, 5 business days, and then a liquidator is going to send a report sometime between that 5 business days and 10 business days. And the report to creditors is basically going to recommend that we adopt the simple liquidation process, and then creditors have until the end of the 20th business day from the appointment to say that they ratify the simple liquidation process. So although you may, as the director, want the process to occur, it's actually up to the creditors and in theory, the liquidator at the end of the day, because if the liquidator believes that we shouldn't adopt that process, then they may, the liquidator might write in their report, look, we don't recommend that we adopt this process at all for these reasons. And that could be because there's some voidable transactions. There's some really good FAQs on the SV Partners website around what a voidable transaction is, so I won't go into that now, but it might be that there is some voidable transactions. There might be some other recoveries that would be excluded under the simple liquidation process that would otherwise be available in a traditional CVL. So in theory, the liquidator still has some say, but at the end of the day, it's always up to the creditors. Now, the fundamental issue that has been identified by a RETA is that if creditors have 20 business days to elect to adopt the process, and the process must start within 20 business days, then in theory, the simple liquidation can't work. It's theoretically and legally impossible. So it's something that the government's going to hopefully change over the next 2 weeks. We certainly hold our breath on that. Otherwise, it might make this whole simple liquidation process redundant, and we shall see. But what we're hoping from that process, the simple liquidation, is that it might save a few $1,000s on a very basic CVL. It might bring a dividend or a better return then to creditors. And that's certainly the hope for the government. And we'll certainly wait to see. But 1 January should hopefully be the start date for that. And we should hopefully by sometime in the end of January start seeing the first of the simple liquidations roll out, and we'll be able to identify what that's going to mean for creditors and business owners and the profession at whole. So that's a summary of what the simple liquidation process is.